Good morning. Good morning.
Good morning.
Right, welcome. And you can start with questions as we are getting ready to deal with the topic for today. And some of you will introduce. So I think there were a few questions that we didn't clear the last time. So you can go ahead and ask so that we polish and finish everything that concerns the Marriage Act, because we are still left with the matrimonial property. So ask any questions, and so that we forget the Marriage Act. Anyone with a question? Are you completely satisfied? You don't, class A, you don't have any questions? Right, so if you don't, we are going to start off with the matrimonial. Right, I see there is someone. Okay, Sudi, you have a question?
Yes. Yes, I do.
Okay, proceed.
In presumption of marriage,
Yes.
what will when your spouse dies,
Right.
will the wife be referred as a former wife, or what happens?
You know, presumption of marriage was a very good arrangement until 2017. When 2017 came about, you find they say all marriages must be, Sudi, all marriages, what must be done to all marriages?
Registered.
They must be registered. Now, this presumption, do you have an idea how presumption of marriage arose, Sudi? Because we are actually going to deal with it. We shall deal with it when we reach the issues of those who will inherit. Do you remember what had happened for that presumption of marriage to arise? It was actually a succession matter. Do you have an idea about it? Or do you recall, you may have done it at the university?
Yes.
You actually ought. What had happened?
If I remember well, okay, in presumption of marriage, you actually stay with someone. Well, you it will be called a presumption of marriage after you stay with someone for a long period and both of you have accumulated property together, you have maybe kids together.
Is that the highlight of what you learned when you are doing presumption of marriage? Was that the main key? Because, in fact, the case in which presumption of marriage was actually held, I don't think the lady had property. But do you remember that case? Because it will help us, or it will direct us on what transpired, because it caused the courts to begin to presume. That's why we say presumption. They began to presume because they thought if those ladies were actually inherited, it would have been unfair. There was a case, a very famous case. Anybody who can help Sudi, if she can remember? Anyone? Anybody who can remember that case? I thought class A, you are very active. What has happened? You become lethargic before you start the classes. Anyone? Okay, Sudi, because I would like us to complete the issues of presumption. Presumption was never, and I hope you know that, it was never in law. It was not anywhere in statute or in any statute, even Judicature Act. Some were saying, could we compare those kind of arrangements where people live together without getting married? And you know, it has become a bit common. And in fact, for your own information, I mentioned, I think, I'm sure I talked about it in all the classes last week, of that lawyer. There was a lawyer who became very wealthy because he represented IEBC during the time of 2017 election dispute. And you find he ended up buying 3 houses in South B. He had 7 motor vehicles. This gentleman, for some reason, never had a wife as such. But the relative said he has 2 children, a son and a daughter, born out of wedlock. They were born by some ladies, but he never married them. But from 1999, you can see that period, 1999, he began to cohabit with a lady. And he has been cohabiting with her all that long. So imagine 1999, you are talking of over 20 years. So he died in March. He died in March this year, yes, this year. And when he was called Muchiri, when Muchiri died, of course, the brothers came up to collect his things. In fact, because of the burial, they had to go to the house. They found the lady and they asked her for his ID to get the burial permit and so on. And they told her not to be seen near the mortuary and so on. So what happened? This lady, she tried to say, I've been cohabiting, I was just like his wife. She was told, okay, if you want to be recognized, you have to go to court. And I think she went to see some good lawyer who advised her, it's only for the court to presume you as a wife because you have no marriage certificate. Perhaps you'll have documentary. In those ones, you have to produce documentary evidence. So I'm sure she has pictures with Muchiri. She may have gone to parties with him and so on and so forth. So you find that lady now, the case is in court. As I said, the man died in March this year. The matter is pending. But when we relate that case of Muchiri to a case which I'll give you when we actually deal with those type of inheritance, is that it was called Simel from Maasai land. And I think I mentioned that. And he married the first wife under statute. And then he didn't marry, he cohabited with 2 others for a period of 30 years. So you can see 30 years is a long time. So when he died some years back, those ladies went to court. That course, that succession course was determined by the court last year in July. Only last year in July, which is 2020, when the law of the Marriage Act was already in force and so on. So what happened, the court held those 2 old women who had been cohabiting with Simel for many years, 30 years is a long time, were presumed to be wives. And they inherited together with the wife with a marriage certificate. So you will find that area is still fluid as of now. You'll be dealing with those cases for quite a while, but you may find, because of Simel was court of appeal case. It's likely to be followed. But from what the impression I've been getting is the period of time that they have been living together. And that period of time, if you recall, I'm sure you did that in university, they said that in Hortensia Wanjiku Yawe, you know that famous case of Hortensia, that is where presumption of marriage came about. And the judge who was presiding was called Justice Mustafa. And Mustafa, in fact, took into account, you can read Hortensia by yourselves, he took into account, Hortensia had been living with Yahweh for many years in South B, and they had 4 children. And when this gentleman, he was a Ugandan, he was a pilot with the East African Airways, that case is an old case. So they said, having cohabited for so long and presumed, that's where presumption came about, that they were presumed by the neighbors. The neighbors presumed them as a married couple. They didn't actually know that they were not married. So they said they were presumed as a married couple. And because of that presumption and the fact that they had children, Mustafa said the presence of children will weigh heavily towards the recognition of the wife, of that lady. And she was presumed a wife, but that was in the 1970s. It was presumed as a wife. She, of course, when we do succession, you know, women don't inherit, but they hold a life interest. But the children, she was holding the property as a trustee for her children and enjoy a life interest in the same, and so forth. So you find that presumption of marriage started from Yahweh versus public trustee. It came to Hinga, you know, the famous Hinga versus Hinga, and concluded by a case of Karanja versus Karanja. Karanja versus Karanja, which, as I say, we shall deal with them in depth later on. So as a consequence, it was a form of marriage. And that presumption I was telling you was equivalent to the customary marriage of elopement, where people ran away because they were not allowed to get married and went to live together. And after a long time, they got children, finally went home and they were accepted and marriage was performed and so on. And that elopement, they could have gone to register if they wished. So those kind of arrangement. There have been several questions on presumption. And in fact, you find presumption in the Evidence Act. They talk about it in the evidence. And because of evidence, they have to produce evidence. But after the Marriage Act came into force, 2017, Section 6 is very clear. There are only 5 different types of marriages. This one, as I say, if you come across a question, you may continue to see questions on presumption to know whether you have assimilated material from the Marriage Act and whether you have understood, in case you have a client, so that you can be able to help that client. The main issue is a period. And I say you can rely on the case of Simel and let's wait for the case of Muchiri to see what is going to be held. The lady had been with the man for a long time. But now, as of now, she's been chased away by the relatives of the man. But of course, she's gone to court and so on. So presumption is not, it has a very delicate environment. And if you have friends who are cohabiting, just tell them to go to the Attorney General. Tell them to get certificates, just in case one of that man dies. Of course, if the lady dies, the man is fine. He will still continue with his property. But the lady, her situation will be sad. However, you can still advise them that in case they have children, children will inherit. children will be recognized. They will feature under Section 29. But for them to appear in Section 29, they must first prove Article 53, subsection 1E. Does that answer your question, Sudi?
Yes, it does. Thank you.
Yes, you just talk about what was, what is, and you can make recommendation. Anybody else? Anybody else with questions on marriage? Okay, so if you don't have question, and I'm sure I told you, please read the Samuel, you have a question? Or you want to contribute to today's subject or today's topic?
Good morning.
Morning.
Yes, I had a question on annulment of marriages. During the last class, you said that if a marriage has been annulled, then the parties to the marriage will be considered as a former wife, for example, if it's a lady. But then when you look at Section 75 of the Marriage Act, it says that the effect of annulment is that the marriage will be assumed to have never taken place.
Correct. Now, Samuel, did you notice you have two sections on annulment? Where annulment started, we talked of Section 11 and Section 12. All right.
Yeah.
Where would that Section 75 be referring to? Which section on annulment?
Let me confirm.
Okay, I can help you. It is Section 11.
Okay.
Have you seen what Section 11 says? Just read it. What does Section 11 say? Samuel.
Yes, I am opening it. I didn't have it open at the moment. Yes, Section 11 is about void marriages.
Correct. That is very correct. What type of marriages are void? And I said that Section 11 is a reflection of Section 35 of the Marriage Act, Cap 150. And what did Section 35 of Cap 150 provide? It was the types of marriages that are void ab initio, void from the beginning. The married couple, maybe one of them assumed she was marrying a very famous person. When they met, maybe the person has said, one of those very famous, whoever they are, and she was quite happy to marry them. And then to realize this person I married is not the one I thought he was. Maybe they looked alike. And so she would go for nullity quickly because said, I married the wrong person. He misrepresented himself. He was fraudulent and so on. So you have those kind of marriages or marrying, or and even I remember explaining a married man marrying another lady in whatever law without divorcing the previous wife. So it was not capable. Section 37 of that same Marriage Act, Cap 150, has said you cannot marry when you are married, and so on. You are prohibited from marrying under any other system of law. And I gave you an example of the case of Akinyi, which happened just last year in July, and so on, where she purported to have gotten married to a Mr. Winter, an Australian, and yet Mr. Winter came to Kenya, left his wife in Australia, and when he arrived here, he pretended he was not married. Although the lady says they married under Luo customary law. The court told her he was incapable. That marriage of yours was void ab initio. It was a nullity, and so on. So you find null marriages are on two fronts. So Section 11 is void ab initio. That one is Section 75, which says It never existed, full stop. Section 12, we talked about it very clearly, is voidable. Voidable. One of the petitioners, the aggrieved the petitioner, would have been aggrieved about something they discovered after the marriage. And when that marriage was being performed, it was a valid marriage. And that one, when they divorce, I mean, when the marriage is nullified, and that has to be within 1 year, that lady was married. She was, every concern that involved a marriage, a valid marriage, was met. So there was no problem. So they can go for nullity, because nullity has two facets. It has void and voidable. Previously, there were in two different provisions of the law. Void marriage was under Section 35 of Cap 150. Voidable marriages were found under the Matrimonial Causes Act, Section 14. So you find that one of voidable marriage is a marriage. And that lady who is going to be voided, or the petition when it goes through, is that she would have been a wife, and she will feature under Section 29A as a former wife. The one avoidable, she will feature nowhere. Samuel, does that make things clear?
Yes, it does. Thank you.
Right. So, okay, Samuel, because you are the last one to talk, can you tell us, I'm sure there is no one with any issues on marriages. Can you tell us what you discovered in the Matrimonial Property Act, and which shall concern us when we are dealing with sharing of property of a deceased person, and pertaining to a former wife? The same one we have just talked about. There is a former wife under Section 29A. What did you discover? Did you read it? Did you read the Matrimonial Property Act?
Yes, I did.
Right. So what did you find? That is very important. And again, it will have an effect on the sharing of property, particularly to that former wife.
I don't know whether this particularly applies to a former wife, but what struck me was under Section 6.3 of the Matrimonial Property Act, you can have two parties to a marriage sign a particular agreement that will state the various rights that they have over property that they acquire during the marriage.
Now, Samuel, I can tell you again for a fact that that provision is superfluous. Do you know why? The Constitution. Did you read in the same Matrimonial Property Act that upon entry of marriage, during the duration and at the end, the couple share equal rights? Did you read that one?
Yes.
Equal. Do you see equal rights? Where do you find it again? And I remember we talked about it. You find it in the Constitution, Article 45, subsection 4. Article 45. If you have information in the Constitution, and then you have contrary information in the Marriage Act, what is your observation about that matter? The Constitution has said equal rights. The Marriage Act has equally said equal rights. And then it is making a provision in Section 6 to say something different. What will happen? How will that Section 6 be viewed if there is a dispute?
Of course, the Constitution will take precedence, but then the drafters of the Act actually took that into consideration and put a proviso that said that the court can set aside that provision if they find that the argument was unjust.
Yeah, I think you young people, I'm sure you are very keen on entering into a prenuptial agreement and so on and so on. It is practiced in a lot of jurisdictions, especially in the United States. Do you know in the United States, you see those very rich people who, and you wonder, even when you take into account actual practice, you know, you are getting married. So you have this nice girlfriend of yours, you are now preparing for the marriage, and then you are a gentleman. Maybe, of course, you could be the rich one, or maybe the lady. You know, ladies nowadays are very rich. Have you heard that gentleman called, what is he called? The guardian angel, a musician, a gospel musician. Whom is he getting married to? Has anybody been taking into or interest in that relationship between the guardian angel and his fiancée? Anyone? Right, I see there's a very nice Samantha. Yeah, I'm sure ladies are taking interest. Samantha?
Old woman.
Now, do you see, this is a young man, but have you heard of this background there, Samantha? Do you know the background of that gentleman? How did
Yes.
this? Okay, tell us briefly.
Guardian Angel grew up in Western Kenya,
Right.
and he was not from a well-off background.
Mm-hmm.
Actually, from an interview he had, he said he used to be a common thief at home in his own home area.
He was even a thief.
Yeah.
No,
So he came to Nairobi to look for greener pastures.
right. So he came to the city, didn't he? And
Yes.
where was he living? Where was he living in the city?
He said various places that I cannot remember.
Right. He was living in Jivanji Garden. Do you know that Jivanji? That open space. And in
Yes.
fact, it was that lady, of course, he became a street boy, but majorly he was operating. You know, those the persons you find in the streets, they operate in different places. And in fact, if you go to if a new person goes to a place of where there have been others, they will chase them away. So I think when he came, he felt he may be better off in Jivanji. You see, Jivanji is a big place, so he could be in one corner and so on and so on. That's how he started life. But then Good Samaritans helped him, he got education and so on and so on. But this lady is the one who, in fact, supported his projects in gospel music. So she, you know, over that period of time, she was taking care of him. He became very successful. In fact, you may be, if for anyone who goes along Nakuru, Naivasha, or Eldoret, Nairobi Road, you will see buses, very interesting buses, called the Guardian Angel. And then what I like about those buses, if you are following one, I think the drivers are good drivers and so on. But then you find some writing on these buses, which says, a prayer a day keeps the devil at bay. Don't you think that was very, very clever? Fine. So that now he's going to get married to this lady. I presume, I am very suspicious. Maybe it may not be, it may not happen. But you find he may decide he's 30 years old. I'm 52. Well, she was 52 last year, so she could be 53. I'm 53 years old. This young man may leave me. And you see, she has children. Her children, I think the firstborn is 30 years, just the same as the fiancé, and so on. So she may enter into a prenuptial agreement that in case you leave me, maybe after, I don't know whether she would want to be left at all. If you ever leave me, you will not inherit any of my property. He may do that. No, not inherit. You will not share, because people who part ways and divorce, they are all alive. They are not dead. So you will not benefit from a share of my property. And maybe she may not go to a lawyer, and maybe she will be very imposing. The lawyer may try and tell her, oh, madam, you know, the Constitution provides this way. She may know, I don't want to hear that Constitution. Write this and even seal it and so on. But you find it will not be affected. And that's why you find what that provision has talked about prenuptial. Even the Marriage Act has those that you can enter into a prenuptial agreement, and that even tortious acts by spouses cannot be held against the other spouse. All kinds of things. But for that matter, issues of property for the living and the dead, they have all been captured in the Constitution of Kenya. And so that's why I was saying that why we are doing this Matrimonial Property Act is simply because you have seen the rights. The same rights in the Constitution have been lifted from the Constitution and are found in the Matrimonial Property Act, that they share everything equally. So my question would be, if they have shared the property equally, and then this lady goes, even the one of voidable marriage, perhaps the voidable marriage one may not have much. Maybe those one, they may not actually happen, because you find the voidable marriage, they would have been together for just a year. But on the other hand, have you noted what is in Section 2 of the Matrimonial Property Act? Because that is very significant. It is very significant, but it has been ignored by a certain decision by Court of Appeal about the issue of that Section 2. Although they brought in Article 45, they said it was still negligible, and so on and so forth. Can anybody tell us about that Section 2? Because it's very significant for us. And because I want to highlight it, since it will affect us when we are doing succession. Anybody? Kennedy, you had said you had opened. Can you tell us? And no, Kennedy, it's okay. I have several. Okay, can I hear from Wangoi? Then we go to Laura, and then Hesbon. Wangoi?
The issue of contribution, lots of monetary and non-monetary contribution.
Right. Yes. Now, okay, just read, because there are some very important aspects, which I think when you are in practice and when you are the advocate of the aggrieved party, you must emphasize. When you see the judges are going towards a different direction, you must emphasize that Section 2 of the Matrimonial Property Act. Okay, I'm going to proceed. Okay,
the monetary and non-monetary contribution includes domestic work and management of matrimonial home, child care, companionship, and then there's management of family business or property, and there is also farm work.
Right. And in fact, there is one, the others all involve an activity. Which one is this which does not involve an action? That somebody has to be doing something. Which one? Laura, can you tell us? Which one of those subsections do you think is a little bit important to us? Laura?
I think it's companionship.
Correct. That is the word. Companionship. Just staying with somebody. In fact, to stay with, well, I'm sure some couples are happy. But did you see what Kirubi wrote? Did you read about what Kirubi wrote? Did anybody take that gentleman is my neighbor. So I used to pray for him to get well. And he had gone quiet, so I thought he had gotten well. And then we were shocked that he had gone. Laura, would you like to, did anybody read something of what he made a comment of? on marriage?
Can I speak?
Yes, please.
Yeah, he had mentioned during an interview with Churchill that he considers marriage a prison and that you are in jail for life. That's what he considers marriage. So he says you have to be prepared to be in jail for life. Yeah.
That's the point. Now, but is that what, when you get married, is that what you expect in marriage? I think either his marriages he was not very lucky. Do you know, when he divorced his first wife, do you know he married a Tanzanian, a very beautiful lady. And you see his house, in fact, even has a swimming pool. You sit in the veranda, there is a shoot, you just, like when you go to Nyali, I'm sure you have gone to Nyali hotel in Mombasa, where you have that shoot where children, even grown-up people, you just go inside and it takes you to the swimming pool. But very interesting, very nice. But this lady, she could not stomach. She was there for, I think, barely 4 years. She divorced and went back to Tanzania. So could we also attribute that association and companionship, that it must be contributory? Because if somebody already is apprehensive and believes this is a prison, it will be a prison for that person. But they maybe there are certain interests. I believe for the educated lot, you just discuss and agree on things. So like if you feel you are in prison, like the gentleman of Microsoft, did you see what the Microsoft gentleman did, who is now divorcing? Before he got married, he had this other girlfriend, and he had told the fiancée that this lady is my girlfriend. And the fiancée said, no, I have no problem. Oh, right. So, and then what happened? He told her, before we get married, I'll be going for holiday with this girlfriend of mine for as long as, we are going to be married, but please, I want to. And the fiancé said, fine, we're going for holiday. But you see, they have been married for 27 years. And you find that is why someone like the deceased would have told the wife, I plan to be having a few girlfriends and even others. Do you mind? So that you agree before you get into the marriage and so on. And so you'll go into that marriage expecting certain arrangements which may not be very comfortable. Besides, I always tell, and maybe it's a good advice, when you are married to somebody, some women are committing suicide. That, oh, he has treated me this way, I'm going to kill myself, I don't know what, and even the men. The people one gets married to, I advise my friends, they were not born with you. They are not your siblings. These people you met when you are all grown-ups. So you cannot, go getting so sad. You are not born with these people. You just acclimatize yourself. If you cannot cope, take a walk. Don't just go committing suicide. It is not worth that effort. Fine. So this companionship, I'm sure a lot would disagree. It is very significant. You can see somebody now has even said it's like being in prison. So that person, and mostly the ones who feel they're in prison, will be the female spouses. And so that sacrifice would mean this person can get some share in the property. And as a result, they get the share of the property when they divorce. They get the share of the property when they, even for nullity. That's why I'm saying Section 12 is also important. She will become a former wife, and she would have received some, because immediately she went to live with this man. He had a property. And in fact, you have cases, the former cases you used to use previously are now also active. There was a case of a lady called Ash versus Ash. For those who used to take interest in property sharing or matrimonial property, which was previously under the Married Women Property Act of England, you find we used to have very nice cases. Kivuitu versus Kivuitu was one, 50-50 sharing, and so on. And then you find this companion, she has acquired property. Maybe when she came to this marriage, the man told her, like in Ash versus Ash, welcome, this is your house. So you see that fact of pronouncement of the fact that this is your property, that Ash case, the lady started to do a lot of improvement on the house, painted the house, in fact, broke the veranda, they say with a 7-inch sledgehammer, and cleared the rubble, planted flowers to improve the scenery, and so on and so on. So it created value on that property. There was more value on that particular property simply because of the improvement by this lady. Now, Kennedy, you want to jut in? Kennedy? I see your hand is still lifted. Do you want to make a comment?
Yes. Yes.
Okay.
I was to make a comment on
Yes.
that issue of 50 sharing of property following Article 45(3) of the Constitution.
Right.
You see now, cases that were decided immediately after the Constitution was passed, like Kivuito v. Kivuito, they were
No, Kyoko,
yes.
Kivuitu was a long time ago. It's an old case.
No, sorry, I was referring to cases that were decided immediately after the 2010 Constitution, whereby
Yes.
the 50-50 sharing of the property as an interpretation of Article 45(3) was
Yes.
adopted, and then later on was adopted.
Okay.
And then later on, there is a judge who referred that to an ambitious way of interpreting the Constitution, which would result to a sponsor-seeking relationship where people get married, and then they frustrate it and they get 50% share. And then now,
you know who that judge is, Kyoko?
no, I don't remember per se, but there's a reason. There's a recent authority from 2019 in the case of AKM versus NN.
Right. Now you find that judge is called Kiage. Kiage actually used to be a lecturer in law school. And of course, he had his practice before he was appointed a judge. And that particular case, you see that sometimes say, read the facts of a case on its own merit. We should not generalize. And in fact, you find their judgment was so lengthy because they kept going, oh, Constitution says this, but now this what happens, this is saying this, and so on and so on. But you find in that case, that lady, you know, those are the ladies they are who are called gold diggers. She was a young woman, quite young. She goes to get married to an old man somewhere in Nyeri. I think this old man, the spouse had passed on. But then what did she do? This woman used to go to Mombasa every so often, go and enjoy, and so on and so forth. And of course, the life of the old man, she will leave him for even a month and take so much money. Maybe, of course, marrying a beautiful lady and you are an old man, you are so delighted. Maybe she may have asked him for the PIN of his, or even he wrote her, you know, to be a joint bank account holder. That one we were not told. But you find she squandered the riches of this man. She is spent and so on. And even the children were complaining that you married a gold digger. You married a woman of a lifeist. She's always just enjoying life. So after 3 years, you see, she was just patiently waiting for 3 years. because she wanted to divorce and expect to get half. And that's why the judges looked at the background, looked at the petition, and realized it was actually a divorce, and realized this woman got married to this soul purposely to enjoy his wealth. And you find, some ladies, maybe it's life which has created people to be a bit different, is that you enter into a marriage purposely because of getting some quick riches. You realize, even you may find this old man is so old, you even maybe want us to hold his hand and to walk with him, and you pretend you like him so much, and so on and so on. All you are doing is marking time to reach the period that you are going to petition the court for divorce, and you create some very, I'm sure even the excuses she may have given for that divorce were not substantial. I'm sure the court felt, when you are marrying this person, you knew he was an old man. And the fact that maybe she may have given some hardship which cannot even be stated, but the court said, you married him knowing. So you had a purpose. You had an agenda when you got married to this old man. And why did you immediately, 3 years were up, you rushed to court? And so on and so forth. That is why it was, as I said, the judges labored greatly to make sure she didn't get half. I think she got a quarter or something. And so, but again, when you say a quarter, and you are talking of a billionaire, that lady will still have made good money. She may have lived alone, a single woman, doing bits and pieces of business or even working. She will not have made that money, and so on and so forth. So you find some interpretation, it will again depend on who your client is. If your client is that lady, you have to fight for her, even to get, if not a quote, to get maybe something closer to the half, and so on. But if your client is an old man, you will, of course, have to come with all kinds of issues, all the evidence to show she was a gold digger. You will be saying, my client here was already an old man when this lady got married to him. Why did he marry him? And why did she rush to court and give this frivolous kind of evidence? We should not stand the test of the court, and so on and so forth. So it will depend who your client is. Okay, Kennedy? Right. So let's take our position now to make a decision. This lady got half of the property, and she went away. When the man dies, she features under section 29A. Do you think she should come for more? What are your opinions? Just give what your opinion is, your own. Because as of now, we don't seem to have a case which has been held of the deceased people, and that the fact that they cannot inherit. What is your observation, your opinion, your recommendation? Anyone? You see, you have to make contribution so that you own this information. If you don't make contribution, you find they will just fly through the window and they will not help us. Anyone? Right. Okay, Wangoi again.
I think as a former wife, she should inherit. However, when it comes to equity, then I don't think she's entitled to inherit, not inherit, to have the property twice.
Right. You are quite correct, Wangoi. The law still provides. But as I've told you, at the back of your mind, remember there is a bill by Kaluma. And in fact, they are attacking that former wife. She may be, it may be amended and she will be deleted. But as of now, that former wife is sitting pretty in section 29A. And you find, because she's there, she's capable of inheriting. But what my observation is, and which, as I say, we have no case yet, if she had received half, why should she come for more? I presume the only time she can be able to get some more when she had already received during the lifetime of the deceased is if he had become very wealthy, and the dependents, when they share, will get much, much more than what that former wife received. And that is when I would think what the law or the courts should determine is that they just give her the difference. If the others are getting 100 million and she had received 50, they should be able to give her 50 so that they all have 100 million each and so on. Fine. And essentially, that is our interest or our objective in learning the Matrimonial Property Act because of inheritance. We are not interested in the divorces. But again, we would be interested because they are going to acquire some of that property and they had already acquired after divorce and so on. So unless you have any questions, we are going to start on the law of succession. And I hope you have read, and I believe you must have obtained the statute because that statute is the key to your subject. Moses? Okay, Moses, and then Brenda.
Good afternoon.
Good afternoon.
I think section 29A, when it made reference to former wife or wives, it was taking in cognizance the situation at the time, whereby you get that a man will be married to a woman, either customarily and or just cohabiting, and then they will live for years, have gotten children, then chase this woman, brings in another woman to the home, and I think it was a way to ensure that the first wife or the former wife is taken care of before right now.
You are correct, Moses, because when that statute was enacted, as we said, it was 1972, although it was not enforced until 1981, is that during those years, you see, we had just come out of independence. People would have married their wives and maybe under customary law. And gradually, they are tired of these old women. And you know, like Hinga, you know the story of Hinga, the policeman. Hinga, was he a policeman or an army, a colonel in the army? Is that he had married, he didn't actually marry, he had cohabited with Mary. For many years, they had actually cohabited for a very long time. But then what happened? Mary had 6 children. And this gentleman had become a big colonel in the army. And of course, when you are appearing in parties, you know, they have a lot of parties, those fellows in the army, they have even the mayors. So you want to appear with a beautiful lady. Maybe Mary was a beautiful girl in her time. But you see, as time goes on, is that a lot of, when people grow old, she was not even very old. But having given birth to 6 children and cared for, she's, struggling there. You see, that kind of life makes somebody look miserable and old, even if they are 40 years old. Fine. So Hinga had gotten a beautiful girl and was going to marry. But then Mary went to court. And I can tell you why she went to court was not even for anything other than for maintenance. She had gone to court under Miller, and the judge was Justice Miller, who was in fact the main judge. Is that the lady, and I'm sure she must have looked miserable. And this man looks at Hinga. And Hinga, of course, was having the beautiful girl next to him. And he asks him, this lady, when you took her, in fact, when he had taken her from school, when you took her from school and began to live with her, she was a beautiful girl. She has given, and in fact, the judge said that she had given birth to half a football team. Here she has given birth to children for you, half a football team, and you have just left her and gone to get a pretty one, whom obviously you must have taken care of, that she's looking so beautiful and so on, with nice hairstyle, and this one is maybe with a head scarf, an old scarf on her head, looking for maintenance. And in fact, what Justice Miller said, he told Hinga and Mary, I pronounce you husband and wife, and get out of my court. So, yeah, and in fact, that case was criticized. That judges should not be marrying. And now that was avoid marriage, because it was performed by an unregistered person. Anyway, so you find that was that case of Hinga. And it was not even for marriage, it was for maintenance. So when this law of succession earlier on took into account that kind of an occurrence, where men, as they become more successful, as they become, rich, particularly you look at these cases of members of parliament, when they die, women crop up from somewhere and said, I was cohabiting, he had bought me something, and so on and so forth. So they had to cater for those type of women who will suffer destitution by the man dying and they are not provided. Although we don't have cases, we don't have many cases, simply because, again, you see, when you divorce, and then most women will go and get married. They will marry somebody else. So the question is, if after marriage, they come and, oh, so-and-so died, let me go and, ask the family to include me as a dependent on the list of beneficiaries. That husband, that lady will be in trouble. The husband will say, you married me. You are now going to claim, so it means you are still having a relationship. So you find we have a very few cases. We have the only case that we have had, maybe the others, but they don't go far, was a case of Kilele. Kilele used to be the managing director of one of these parastatals. He divorced 2 of his wives. By the time he died, he was not even married. He was cohabiting with a beautiful Maasai girl. So those women came and said, firstly, this one is just the one who made us to be divorced. And she's not even a wife of this man, and so on. We are going to share property. And this cohabitee had a will. You see, when you bequeath somebody property, whether they are cohabitees, girlfriends, is irrelevant. So she produced the will. And of course, it was challenged. And eventually, the two divorced wives and their children and this cohabitee all shared. But that was before 2017. It was some years back. All right. Brenda, you have something contribution?
My question comes from the scenario where two parties get divorced, but they do not share matrimonial property then, or the issue of matrimonial property is not dealt with at the point of divorce. So would it be right to say that Section 29 also covered such a wife? And in the event the bill that you discussed comes into play, will the how do I phrase this? Yes, wouldn't it be prudent to have this wife get their 50-50 share, in as much as there is another wife who had, maybe the man had remarried or not?
Right. Brenda, you see, if that bill is passed and it becomes law, it is meant to amend the law of succession. But so you will find Section 29, the one they want to remove is that former wife. So she will not be there. She would have been removed from the statute. Equally, when people divorce, I can tell you for a fact, the next step is to share the matrimony. You realize now divorce would have been after 3 years. During those 3 years, the possibility is that they have acquired some property. That is a presumption. Of course, after divorce, if there is nothing, then there is nothing, and they cannot share anything. If people were just even renting a house, they were just, they didn't bother, but I'm sure they will have a car. That car, of course, will be valued, and so it is property, and it can be shared, and so on. So you find in the majority of cases is that former wife, if she received some, I said, my only observation is that the court has discretion. Courts have discretion. And that is why they can decide cases and not follow what the law says, because they have discretion to deviate, but they have to support. They have to support. Because as I'm telling you, the Kiage case of this Mary lady is that they had to deal with, and even they made provision. They brought in the Constitution, and they say, although the Constitution says this, unfortunately, the behavior of this woman was not that she had gotten married because she wanted to live permanently with that. And you know, they say marriage, which again is like people curse themselves, because they will be saying, till death do us part. But now, after this one will be saying, till death do us part. But she knows she's going to be there for 3 years. Phoebe, you have something? Phoebe?
I want to build on what brother just asked. And
Yes.
I was going to ask if, assuming now at the point of divorcing, they have nothing.
Yes.
And but they have children.
Right.
And after, along the way, the man accumulates some wealth and even remarries and only provides for the children of that marriage. Would the former wife still be able to come back and claim some property?
Right. As we are speaking, we have no case. We have no case. She may not claim for property, but as you have said, the man is maintaining the children, isn't it? There is maintenance. Equally, had you read the Marriage Act up to the end, you would have found a divorced wife. You see, when a wife is divorced, or during the time the divorce petition is still pending, it has not been determined, that lady, the court will order the man, if she was a housewife, if she was jobless, to maintain her, to continue maintaining that lady. Just read the statute towards the end, maintenance. he will maintain her. And you notice they didn't have anything to share. So she'll maintain her until circumstances change. If she gets a job, the man will run to court and say, she has a job. She can take care of herself. If there are children, he will continue maintaining those children indefinitely until, of course, maybe they complete education, they have jobs, and they are working. Then his business comes to an end. You remember there was a case of a man in this country who took the father to court. Why? Even not the parents to court, because he was doing a master's degree. He had been educated until he got his first degree. Then he went for a master's degree, and he wanted the parents to pay. And the parents refused. They said, we have educated you. You are now over 25. Why are you still coming for us to maintain you? Because after 18, you become an adult. But of course, the law provides that if the child is still undertaking education, they have not finished the first degree, you continue paying the fees. But when somebody has completed first degree, they don't want to work, they just decide they are going to be under the maintenance of the parents, the school fees, the food, the housing, and so on. In fact, that case was thrown out. But this divorced woman would, before she gets some support, she is able to work and get money for herself, she will be maintained by the husband, the former husband, and she will be maintained. If he dies, before this maintenance comes to an end, in fact, which is very interesting, the Marriage Act, in fact, fortifies Section 29A of former wife. She will end up becoming a creditor. We are going to do those things. She will be a creditor. She will be a liability to the estate of the deceased. That one is just certain. She will be a liability. She will have to be included on the side of those owed money by the estate of the deceased husband. Okay, Brenda, that's how it works. It is even in the Marriage Act. Just read what I'm advising you, read all these statutes just like a story. You read storybooks, just read them as story, and you'll find certain highlights like that one will not escape your mind. You take that into account and so on. Right, any last question so that we go to the law of succession. We have to start the law of succession today, at least from section 1 up to 4, 1 to 4. Those are significant and they are the initials. Anyone, any further question? Or now you are settled? And if you are settled, because Brenda, you are the last to ask, can you tell us what you discovered or what highlights you like to bring up under the law of succession, at least up to section 4? Brenda, did you read?
Yeah, sorry, I'm having trouble with my internet connection. So
yeah,
basically, as you know, it the section that actually focused on most was the interpretation part, just to understand the terms, the different terms that are very necessary to succession.
Right.
And for example, the meaning of a wife, and then the corresponding meaning of also, if it's the wife who died, the husband. And then when it comes also section 4 as well on the application of succession, and where it discusses both the matters of domicile. So both Kenya, movable property in Kenya, and which shall be regulated by our laws here in Kenya, and then movable property are regulated by the country of domicile. So for example, if John and Mary were married and then John has movable property, let's say in Uganda, the succession of that property will be in accordance to the laws of Uganda.
Which type of property?
Movable. It has to be movable.
Right. That one, we shall deal with it. We shall deal with it and explain it properly. And when you reach section 4, we have jumped the queue. Is that write section 4 and then put a stroke and write section 77 of the law of succession. Those two have interesting bearing, but we shall deal with them later on. But I wanted us to have started, because when you look at your course outline, you'll notice there is something they have said about conflicts. Some conflict. This statute, he's saying something and is conflicting with others. Did you find anything which you thought is not proper or is conflicting with the laws that are there or even of itself? And in fact, you'll find that at the beginning. You see, the preamble was essentially what all those laws we had talked about when we came from Mombasa to Kisumu and so on, is that we said there were all these laws, but the first president of Kenya wanted all the laws, made into uniform laws so that there is no confusion, and it was done. So we had one statute of the law of succession. And then you find this statute, and if it has said the preamble is to unify. And then when you go, that is section 1. When you go to section 2, what did you discover? Anybody? For those who read, what did you discover about section 2? Because it is creating some conflict. Maybe you found out, maybe you didn't, or maybe you didn't read. But those who did, can they tell us what they found to be contradictory? They are contradicting each other in section 2. Anyone? Do you know if you want to write? So I see, Laura again. Laura, and then we shall be helped by Wangoi. Now, those who are making contribution, I can tell you when they pass, they will pass very well. And those who are just sleeping will complain. But make contribution, read, because they are going to help you in your oral examinations are not very far away. Project work is en route. Okay, Laura.
I'd like to make an attempt. Section 2, subsection 2 speaks about estates of persons who died before the commencement of this act, that the customs apply to, the customs that will apply to their date of death, but the administration of their estate will apply to will have to be in accordance with the act.
Right, so you see, 1 minute, it is saying when the time they died, the laws that existed applied. But for administration, it will be the law of succession. So you see, you are jumping from one leg to the other. But that aside, I thought we didn't need to bother because the law of succession, happily, has been in operation for many years, and that will not be caught by subsection 2. But when you look at the case of Koinange, Koinange was, and in fact, Koinange was the Koinange Jeff, the Jeff you see on KTN, the one you know very well, is a relative of Koinange. That case of Koinange, and I'm sure is one of the beneficiaries, has been on for a long time. It is not being determined. When it is about determined, they appeal. Then they appeal, they go up to the Court of Appeal, and then the case is returned back to the High Court. It is in the High Court and so on. It has been going on for 40 years. So that section is still applicable and so on. So that is why they can go to court and so on, object, petition, object, and so on and so forth. So, but now you left section 2, subsection 1. Wangoi, what did you discover about that section?
It says that it shall be applied universally
Yes.
to intestates and testamentaries who died after the commencement of the Act.
So what impression have you gotten?
I'm not sure.
Okay. Now, who kind of had a thought, right? Brenda?
I'm not sure, but this is what I think.
Yes.
Basically, if someone died before the commencement of the Act, but they had not instituted any succession proceedings, or no proceedings of succession or administration had already begun, this person is left in somewhat of a loop because they died before and proceedings have not yet been instituted. That's what I got.
How could this person who was not dead institute succession proceedings? He was not dead.
Oh no, I'm saying.
Yes.
What's it called? For example, someone died before the commencement of the Act, meaning they'd be governed by the laws, that the previous laws, but no proceedings of probate and administration had been instituted.
Right.
So the person's coming.
Brenda, that is actually section 2, subsection 2. You are in 2. You are not in 1. Okay. Have you read that one? Can you hear? Yes, you've read it. What does it say? It doesn't talk about what you're saying.
Oh, I think I understood both of them then in the same manner.
Or you mix them up.
Yes.
They're actually very different. Can we hear from Victoria? I saw Victoria.
Good afternoon.
Good afternoon.
I think what I got from section 2.1 is that if someone died before the commencement of the Act, then the law of succession does not apply to their succession. That's what I understood.
Victoria, that is 2. That is section 2.2. Why did you pick something in 2.1? Okay, Noel.
Okay, what I picked is that the Law of Succession Act will have universal application effect. However, when it comes to Muslims, they are guided by the Muslim law.
Right. Now, do you see, so that word which is sticking out is what? That word, which is just kind of springing out of that section 2, subsection 1.
Universal application.
You see? Now, universal application. And then again, it says, when you hear of universal application, Phoebe, what impression do you get when you hear universal application?
That it's going to be applied without any discrimination. That should apply to everyone.
Correct. It's going to be applied to everybody. And then what does it say again? Yes, Laura?
Except for Muslim. Okay.
Now, is that universal? So you find, I think sometimes when drafters of bills, and before they begin to think, they should take time, they should take their time to review this information. We are saying universal, and then we are saying it doesn't apply. This word, we should use it differently. We should use a different word. Moses, you want to contribute?
Yes, Mwalimu.
Right. Proceed.
Good afternoon.
Good afternoon.
But I think that that provision is well provided for, noting that it starts with except as otherwise expressly provided in this act. That alone, the starting point of the provision is a disclaimer to the rest of the intention of the provision, which is universal application.
Why would they not have just said this law will apply to those intended, instead of saying universal, and then coming again and qualifying? Was there any use? Is it of any use that you have created problems? Somebody would say universal, and then and in fact that is why I think it was class B who are arguing about the Muslims. We argued until we almost used the whole class for just talking about Muslim. I see Alan Wafula.
Actually, I had the same thought as Moses, that they had made a disclaimer. And then I'm thinking that the act is still universal. It applies to Muslims as well, but it only applies with regards to administration. And if you read also subsection 4 of section 2, the exception that has been provided. So the word universal, for me, I think, in my opinion, does not have a problem, because Muslims are also captured to some extent.
Oh no! Have you heard that they don't apply the law of succession at all? They can appeal when they appeal, but when they appeal, their laws are going to be upheld. And you know, Muslims have been provided for under the Constitution. You know that is there. Are you aware that they have been told for your personal laws, you use yours. For your personal matters, use your laws. Marriage, succession, divorce. They use their law. They don't use the law of succession. They ought not to use the law of succession because they have been, I believe why you have the view that you hold is because you don't know the background of, and I think I explained, of why the law of succession, which was passed in 1972, was not enforced. It was passed, it was assented to, was not enforced until 1981. And what was happening? Muslims say they were not going to take that law. They were not going to apply the law of succession to their matters, their personal matters. They didn't want it. And they agitated from 1972 until 1981, when the law was amended and it was discontinued as far as Muslims were concerned. That one, don't forget. Don't say it is universal. It is not. And in fact, I'm going to tell you a few more areas that you will know it is not universal. And why they use the word is a mystery. Fine. So section 2, subsection 2, there is a problem. No, section 2, subsection 2 is confusion of if you died, you use the law that was in existence at the time of your death. But for administration, we shall use the law or the law of succession. That's a further confusion. That's a further conflict. That's a further area where it can cause confusion, but the only lack is that we don't normally bother. Section 32 of the Act. I'm sure had you read further, Section 32 of the Act, in fact, states that for agricultural land, livestock and crops thereon, the law of succession does not apply. And that the laws that will apply under Section 32(2) is customary law of the persons concerned. So now, our universal issue again has been hampered. It has been set aside. You have said this one, the law that applies will be customary law under Section 32, subsection 2. So where is universality? Where is that uniformity? Fine. Equally, this is highlights. These are things you have to take into account. You have property of a deceased person who had taken a life policy. When you take, for some of you may have life insurances, you insure yourself. That I insure myself, and there is a provision that if you insure yourself, you have to nominate somebody. You are the one who has insured oneself for a certain amount of money. But then in that form, you'll be told to nominate somebody in case you pass on before the maturity, the period that policy is to mature. So if it has not reached the period that it has to mature and this person dies, who will get what he had insured for? Who will get the money? So you have to point out, you have to say, this money, I nominate so and so. And even if a man, for example, has 3 wives, maybe he has a favorite one. He has one he loves the most. That one is going to receive, if he nominates her, and maybe had insured himself for 1 million shillings, and he dies before, and I hope once he has insured himself and he has written the name of this spouse, he should not tell her. He should not tell her because of obvious reasons. Is that lady will receive the 1 million. And even if you are the 2, those 2 will not come and say, oh, insurance, Jubilee Insurance, we are also his wives. They will say, look at the nomination form and look at who is written, and it has an ID number. So this favorite, this nominee will just take her, maybe it may not even be necessary. She'll just take her ID and go and show, and maybe just to fortify things, because the ID has her photograph, it has her number, it has her name, everything is there. She will be awarded that 1 million to the exclusion of all the other relatives. So now that's his property of a deceased. The property of a deceased who died, having nominated somebody, it will not be included in the assets of a deceased. That one will just be inherited directly by the nominee, and the nominee will just disappear with that money. Even if she's taken to court by the others, the judge will say, oh, sorry, this is not under the law of succession. Now, that's one of them, nomination. And you'll find in your course outline, they are indicated. What is the other type of property that somebody is nominated and nobody else can get, even the children? That is or whoever, maybe he can nominate his child, the child he likes the best, is the cooperatives, the people who have money in a cooperative. You have the teachers, the cooperative, you have like Sharia cooperative, and so on and so forth. Those cooperatives, when you are a member of a cooperative, you fill a form. Of course, they take your details and they will tell you to nominate somebody. Previously, you didn't have to. But in 2019, the Cooperatives Act was amended. Section 39 of it provides that you must nominate a beneficiary in case you die. Of course, some people will work until perhaps they die in office, or they are still members of that cooperative, because most of these cooperatives are, the membership are drawn from organizations. So like Kenya School of Law, there is a cooperative which governs these systems of the legal judiciary, all those people, and so on. So whoever is nominated, nobody else will take their money. That is, again, money over deceased. But that is deceased had nominated somebody. Nobody else can get it. And then you will go to section 31 of the law of succession. 31 of the law of succession. Universality does not exist in section 31. And when you look at section 31, it involves gifts in contemplation of death. Gifts in contemplation of death. And now the donor will donate a gift to a donee. Let's say a car, to tell maybe he's expecting to die very soon. And we are going to go into depth in that part as well. Is that he expects to die. And then he gives a friend a key to his car and say, should I die, my friend, you've been my best friend, you'll take that car, and so forth. So you find that section 31 again is not going to be catered for under the law of succession. Whatever has been gifted to a donee during the lifetime of the deceased, when he dies, the family will just transfer that property to that nominee. They will not even include as part of the assets of a deceased. So again, you can see section 3, subsection 1 is in conflict. So those are the, and equally, you from section 31, go to section 43. And you find in section 43, I hope you are noting those down, is survivorship. Survivorship. What would have happened is that, let's say even a couple, it could be a married couple, because we have a case of a married couple. You buy property under joint names. So you buy property, let's say they are Mwangi, John Mwangi and Jane Mwangi have buy property under joint names. When one of those dies, it could be either of the spouses. When one spouse dies, the property transmits to the survivor directly. Directly. You don't even go to court. The survivor will just take the death certificate and a certified copy, go to the Ministry of Lands, wherever that property is situated, and give this, show the death certificate, give a certified copy for the file, and they will cancel the name of the deceased and issue a new title in the name of the survivor. So you can see how there are areas that the law of succession does not operate, although they are properties of deceased people. So survivorship, is one of them. And in fact, you may have done it under land law, where they said it is operation of law. Jus accrescenti. Jus accrescenti, it just transmits to the living. And because I can see your time is running out, so these ones you are going to deal with by yourself. So you can see the fact that you are saying there is a disclaimer, we can say this and so on and so on. Now you have others which are even worse. They have now indicated this law of succession is not for universal application. It doesn't apply to this property, and they are yet they are property of deceased. Doesn't apply to the one which was held this way because of this, and so forth. Fine. So that is section 3. 2. Section 3, subsection 1, because of your time, I would like you to ensure that you read. Somebody had picked up section 3 and the words and the wife. I don't know why you picked up the wife. And in fact, that definition of a wife, a separated wife, being a wife, is they have not divorced. So how can you say she's a former wife? She's not divorced. Equally, there are certain words which I would like you to read section 3, subsection 1, definition section very clearly. You read by yourselves. And I'm going to, next week, the first question will be certain words. Can you state the words you have found to be not quite clear? Because the way they are used in the law of succession and the way they are used ordinarily are totally different. And it is going to be your duty to identify those words. And perhaps because I have your names on the screen, I think perhaps I'll help those who have never answered question by calling a name. So just make sure you read the order of section 3, subsection 1. As we have touched on section 4, we don't have, I've told you section 4, we shall deal with section 4 in depth when we reach section 77 of the law of succession. So for next week, we shall go through that section 3 quickly. Section 4 we have covered, and then your work for next week will be section 5 to section 13. And that section 5 to section 13 is in fact the key component of the law of succession, the key component of issues of your inheritance. And that is the wills. That concerns wills. That we have cases, I'm sure you'll also have your own cases, but I have some old cases which we can use as our authorities, and all being equal, you'll be able to receive through your mail the cases that we shall use for our study. And in fact, from that section all the way up to the last section of the law of succession. Any last question? I saw a hand. You have 5 minutes. Right, Daniel?
Yeah, good afternoon.
Good afternoon.
What would happen in a situation where a party is claiming donatio motiscosa under section 31 of the Law of Succession Act, and the property that the person is claiming is also provided for under the will? Which one would suffice?
No, okay. Daniel, I can just direct you to read that section 31. You will see what they have said. Firstly, it is movable property. Secondly, is a type of property which could have been willed in the will. So essentially, it means section that one has provided. You are not going to give such property, such movable property to a donee, and then at the same time, will it away in the will. No. Once you have given, for example, the key to your car and told your friend, when I die, or should I die, because sometimes they recover. In fact, in the same provision, there are different sections. There are different provisions in that section 31, which says he may ask for that property back. He may actually, if he recovers, he'll ask for his keys back, and so on. And once he has given in the gifted, and you know you'll have given the keys to a friend, is that when should you write a will, you cannot include. Just read those A, B, C, D in that section. You'll see you don't will away what you have given to someone, to Adoni, as gift in contemplation of death. All right.
Yes, thank you.
Okay. Now, one last question. We still have a few minutes. We have to utilize our time. Just ask or contribute or comment. Are you now convinced that the law of succession has conflicts? I think whether you are convinced or not, that is the position. And I hope you already will be looking at your course outline to see how we are moving, and so on and so forth. And the kind of books, because you have stated that there are certain books that you need to read. Edwin? Last question.
Good afternoon.
Good afternoon, Edwin.
As regards the separate application of Muslim laws,
yes,
Article 47(1) of the Constitution provides that every person is equal before the law and has a right to equal protection and equal benefit of the law. Isn't by distinguishing the Muslims from the rest of the people, isn't that creating a two-tier cluster where we have we have two different laws applying to two different kinds of persons, when the Constitution clearly says the law is applying to everyone and everyone should be just equal before the law and there should be no distinction?
Now, Edwin, because they agitated. Do you know, last week I had a class B. Oh, they argued about this Muslim. In fact, there's someone saying this is so unfair. Oh, but then there was a Muslim who helped us. In fact, they said they are very happy. They don't want to be interfered with. But you see, again, Edwin, that started from when we navigated the laws from the coast. You remember the coast was an Islamic 10-mile coastal strip, was under the Sultan of Zanzibar, who was a representative of the Omani king from Oman. They had ruled that coastal part. They were using their laws. And if you, as I have said, go to Dubai, and even it is just recently, it was the early this year, when the Muslim ladies, there was a princess who had been agitating for women to be allowed to drive. Do you know in those countries, you go around, and in fact, you don't see women driving. Women are just being carried all over the place, and so on. But this particular contributor said they take care of their spouses. Even women don't work. Those who, 99% of them, they don't work. They just sit and enjoy. And of course, they have these ladies who go mostly from Kenya. Some of them, the majority are from Philippines. They work for them. So they're just, they just beautify themselves. And you look at those ladies, they are so beautiful, and so on and so on. They are very comfortable with their lives. And in fact, just check, I think it ought to be some other section apart from that one, that has given, and in fact, during the time of debate for the Constitution, they had said that they want to be governed on personal issues by Islamic law. And the Islamic law is not written anywhere, it is in the Quran. And they are comfortable, they are not complaining. So why should we be complaining on their behalf? They don't want even anybody to bother. They are happy. Edwin, those people are very happy. They don't want to be interfered with. So just look again at the Constitution. You'll find that they have been told that it is okay. And even at that point in time, if you perhaps, if you are taking a keen interest, but you could have been in high school or something, they agitated to be included in the Constitution, to be said you use your law. And even Christians were saying, then even Christians also should be given recognition in the Constitution that they can use their law. But somehow Christian didn't succeed. But Muslims, because they said we started using our laws in generations or many years ago. And in fact, you notice Mombasa, Christopher Columbus, no, Vasco da Gama, when he was passing, what did he do? And so on. They built for Jesus. And in fact, it used to be under they built for Jesus to chase away the Muslims. But then Muslims gradually came and fought with the Portuguese and got rid of them. And that was, you are talking of, was it the early, over 100 years ago, and so on and so on. Just read the story of Vasco da Gama and how they had filled a fort, but it didn't help. They were overthrown. Otherwise, would have been under the Portuguese, and you can see what is happening in Mozambique. I'm sure you not have wished to be under the Portuguese. Or Edwin, would you have been happy to be under the Portuguese and not even the British? And so on. Right. So you have your work. So we start from there, and the key will be section 5 to 13. So have a good week. Our time is up. They have been a bit kind. They would have locked us out.